Chapter 8 IPC describes and defines offences against public tranquility and it prescribes punishment for them. The first section 141 is important. It defines an often used term, unlawful assembly. An unlawful assembly has two characteristics. It is an assembly of 5 or more persons, and the common object of these 5 or more persons should be one or more of the following 5 objects. This is the first one. To frighten, to pressurize any public servant in exercise of his lawful power. To frighten, pressurize the central or state government or parliament or state legislature, either by use of criminal force or by show of criminal force. Second object, to resist execution of any law or legal process. Third object, to commit any mischief or criminal trespass or other offense. Fourth object, to take possession of any property, to deprive any person of enjoyment of a right of way, of use of water or other incorporeal right, to enforce any right or supposed right. All this either by use of criminal force or by show of criminal force. Fifth object, to compel any person to do what he is not legally bound to do, or to compel any person to omit to do what he is legally entitled to do. This also by use of criminal force or by show of criminal force. So in 3 of these 5 objects, use or show of criminal force is involved, and in the remaining 2, in one there is resistance of law, in the other there is committing of offences. The explanation provides that an assembly which was not unlawful when it assembled, an assembly which was not unlawful when it began, may subsequently become an unlawful assembly. Maybe in the beginning it did not have a common object which was one among these 5 which we just now described, but subsequently it acquired any one of these objects and it became unlawful. We will go through a recent judgment of the Supreme Court in the case of Vinu Bhai versus Rajiv Bhai to understand this concept of unlawful assembly. In this judgment, the Supreme Court has explained the characteristics of an unlawful assembly. Section 141 IPC declares an assembly of 5 or more persons to be an unlawful assembly if the common object of such assembly is to achieve any one of the 5 objects enumerated in the said section. We can say any one or more of the 5 objects. It can have one of these 5 objects, it can have more of these 5 objects. Mere assembly of 5 or more persons with such legally impermissible object. Now all of these 5 objects are legally impermissible. These objects are sought to be achieved by use of criminal force or by show of criminal force. These objects comprise of committing of offences. So these are legally impermissible objects. Mere assembly of 5 or more persons with such legally impermissible object itself constitutes the offence of unlawful assembly punishable under 143, it is not necessary that any overt act is committed by such an assembly. The mere assembly, even if the assembly has not done anything wrong, the assembly itself is unlawful. It is punishable. The common object of an assembly is normally to be gathered from circumstances. Now, an important question which often arises in practice is how to find out the common object of an assembly. And here is the answer from the Supreme Court. Common object of an assembly is normally to be gathered from circumstances like the time and place of the gathering, the conduct of the gathering as distinguished from conduct of individual members. And then the Supreme Court gives example. If more than 5 people gather together and attack a person with deadly weapons resulting in his death, it is wrong to conclude that some of the members of such assembly did not share the common object with those who had inflicted fatal injuries, merely on the ground that the injuries inflicted by such members are relatively less serious and non-fatal. Now the court is taking an example where some members of the assembly inflicted fatal injuries, other members of the assembly inflicted less serious and non-fatal injuries. And the court says that the fact that the other members inflicted less serious injuries does not mean that the common object of the assembly was not to cause death of that person. Identification of the common object essentially requires an assessment of the state of mind of the members, mental condition. But where do we find proof of the mental condition? The court says proof of such mental condition is normally established by inferential logic. Now we will devote some time to understand the third object, which was to commit any mischief or criminal trespass or other offense. This is a common object of such unlawful assemblies, and that is why there is a need to understand the scope of this object. Now in this object, two offenses are mentioned by name: the offense of mischief, the offense of criminal trespass. The offense of mischief is defined in section 425 IPC. Criminal trespass is defined in 441 IPC. Two offenses are mentioned by name, and then comes the last part which says other offense. Now what is the scope of this expression other offense? Does it include only such offenses which are of the same kind as the offenses which are first mentioned by name? Or does the term other offense include every other offense without any qualification, without any restriction, without any limitation? Now there is one tool of interpretation in such cases, one principle which is known as the principle of ius dum generis. The question is this expression other offense to be interpreted by the principle of ius dum generis? Let me first tell you what this principle is. Ius dum generis means of the same kind. When is it to be used? Where in a statute there are general words following particular and specific words, then the general word must be confined to things of the same kind as those specified. The principle of ius dum generis shall apply in a situation where in a statute there are first particular and specific words, and then there are general words. Then as per this principle, the scope of the general words is confined to the things of the same kind as are specified by the specific words.